With the acquittal of Daniel Penny in Manhattan, it's clear that Democrats are going to have some difficulty rounding up political prisoners for the next few years. As that trial demonstrated, they can't even sell a BLM narrative to a jury full of liberal women and a guy wearing a COVID mask, by the way. People are more skeptical of race hysteria now across party lines. They understand when they're being manipulated. They care more about facts instead of whatever the corporate press is saying. And that's all very bad news for Democrat prosecutors who are looking to collect a scalp. But this development is obviously small comfort to the many victims of these prosecutors who are still languishing away in prison after being convicted in show trials to appease the mob. And of course, maybe the single most prominent of those victims is Derek Chauvin. Chauvin was as you know, a police officer in Minneapolis who went to work in May of 2020 with the goal of protecting his community from violent felons, people like George Floyd. He's been sentenced to more than 2 decades in prison because Floyd, who had a recent history of overdoses, died in his custody while high on fatal levels of fentanyl. Now, the issue of causation was the single most important issue of the trial. That is the question of whether Chauvin actually killed Floyd. If Chauvin's actions weren't a substantial factor, quote unquote, in Floyd's death, then under Minnesota law, he's innocent. And that pretty much sums up the entire case. That's the whole thing. But after the trial was over, the jury came out and publicly admitted that they didn't really care about this issue at all. Causation just didn't really matter to them. They gave an interview with CNN where they explained that, in their view, Chauvin's actions didn't matter at all. Instead, they determined that Chauvin was guilty because of what he didn't do. They didn't convict him for murdering Floyd. They didn't convict him because his actions caused Floyd's death. Instead, they convicted him for failing to care for George Floyd in some kind of unspecified way. Watch.
We got to the point actually that we realized for charge 2, at some point, I think it was Jody, I'm pretty sure it was Jody, said, wait a minute, does the intended act of harm have to be the death of George Floyd, or can it be him not providing the life support? And it was like all of a sudden light bulbs just went on for those people, I think, that were undecided or on the not guilty side.
Yeah, go ahead. I want to hear from you, Jody. Why is that? You brought that up? What did you?
I brought that up because
Tell me what you brought up and why.
I brought up to the fact that this is not what he did, but more or less what he didn't do. He did not provide life-saving measures for George Floyd when he knew that the guy was in pain or needed medical attention.
Why do you think that was a light bulb?
Well, when we were in deliberations, and Jody did bring that up, and we did look through everything very, very carefully, what I thought about is something that was said during the trial, and that is Minneapolis Police Department has a motto. And if I'm understanding it correctly, their motto is, in our custody, in our care. George Floyd was in their custody. He was never in their care. And that, for me, it just hit hard. I don't feel like they ever cared for him.
You know, it's an incredible piece of footage. First of all, there's no reason for a jury to be looking for a light bulb moment which allows them to rationalize a guilty verdict, unless they were looking for some pretext to convict Chauvin, which they obviously were. The jury shouldn't be trying to find a way to get a conviction. They should be looking at whether the prosecution proved its case beyond a reasonable doubt. And if they find themselves doubting the prosecution proved its case, they don't get to rewrite the law to help the prosecution out. But in this case, it's exactly what the jury did. They ultimately decided to hold Chauvin accountable for things he didn't do. He didn't respond compassionately enough to George Floyd's overdose or live up to the police department's motto, I guess, even though none of those things, even if they were true, would make Chauvin a murderer. The new rule, according to this jury, is that police officers have an obligation to perform CPR on violent suspects the moment they say they can't breathe, even though Floyd was claiming that he couldn't breathe just a few minutes earlier when he was resisting arrest and struggling with the officers in the back of a patrol car. And if police officers don't administer CPR and someone dies, they will just assume that the officer killed them. We'll just make that leap of logic because, why not? But just because the jury didn't consider the issue of causation to be relevant, that doesn't mean that it's not relevant. From a legal perspective on appeal, it's still very important. And that's why a federal judge in Minnesota named Paul Magnuson, who was appointed by Ronald Reagan, has just issued in the last week a ruling that could ultimately lead to a new trial in this case. This is a decision that's worth looking at and dissecting at length because it highlights what a farce the trial of Derek Chauvin really was. No matter how corrupt you think this trial was, it was actually a lot worse than you probably think. Now, the decision came in response to a motion filed by Chauvin's new lawyer in federal court. Chauvin's legal team is seeking to have his conviction overturned in part because his previous lawyer was ineffective to the point that he denied Chauvin his constitutional right to a fair trial. And there are other objections too, including that many of the jurors said they felt threatened by the mob. So Chauvin obviously didn't get a fair trial because they thought that their lives were in danger if they didn't convict, which they probably were. Not that that excuses them. But there are two central claims in the motion arguing that Chauvin received ineffective assistance of counsel. And the first is that Chauvin's lawyer during the trial failed to tell Chauvin that a doctor had determined that George Floyd died due to acute heart failure resulting in pulmonary edema and death. Now, there were indications that Floyd had a heart tumor that could have caused sudden cardiac death, and Chauvin was never told about that, nor was it brought up at trial, even though it seems like an extremely relevant fact. The second claim is that Chauvin's lawyer should have listened to the doctor and ordered tests on samples that were preserved from George Floyd's body. Those tests could have determined whether Floyd died of a type of myocarditis or some other heart ailment. And now, several years later, the federal judge has finally allowed Chauvin's new legal team to conduct those tests. Depending on what they show, they could completely undermine the prosecution's argument that Chauvin caused the death of George Floyd. And that, in turn, could lead to the conviction being thrown out and potentially a new trial if prosecutors decide to pursue it. Now, one of the reasons this is such an important ruling is that in Chauvin's trial, there was clear evidence that the prosecution lied about the concentration of fentanyl in George Floyd's system when he died. And if this case is tried again, this is going to be a major issue. Now, you might remember that in the initial autopsy report, the medical examiner determined that Floyd had lethal levels of fentanyl in his system. He said that there were no physical signs of strangulation and that it looked like a textbook overdose. But shortly afterwards, his assessment changed. Watch.
Medical examiner Dr. Andrew Baker testified that in his initial autopsy on George Floyd, he found no physical evidence of asphyxia and that coronary artery disease and hypertension contributed to his death. Baker later added Floyd's high level of fentanyl and other drugs in his system also were factors in his death, as was the police restraint. Baker says his office received hundreds of complaints and threats as a result of these findings, but Baker denied he ever felt pressured to change his conclusions.
Now, the threats and political pressure we're supposed to conclude didn't influence the medical examiner. We're supposed to pretend that he somehow wasn't bothered by the mob that was threatening to destroy the entire city of Minneapolis when he changed his determination about the cause of George Floyd's death. We're also supposed to think that Democrats in Minneapolis didn't exert any political pressure at all. But as the reporter Liz Collin found, there was even more pressure on the medical examiner than many people realize. Here's one internal memo from a prosecuting attorney in Minneapolis at the time. And as you could see, according to the memo, on May 26, 2020, a team of 6 FBI agents met with medical examiner Andrew Baker to discuss his preliminary findings. And then after this meeting, he changed his conclusions. He decides that Floyd's death was a homicide caused by neck compression and that fentanyl wasn't the cause. A new trial, if that's where this goes, would offer Chauvin's new defense team an opportunity to pick this claim apart. And this is an opportunity that Chauvin's first legal team missed completely for some reason during the first trial. Outside of a few accounts on social media, people like Data Hazard, for example, no one's really talked about this, but it's an incredible oversight by the defense team and a remarkable act of corruption by the prosecution. And if anything completely blows apart the case against Derek Chauvin, it's this. So here's the moment in the trial that I'm talking about. This is maybe the single most important testimony in the whole case. The prosecution is questioning a forensic toxicologist about the levels of fentanyl in Floyd's blood, and watch how that unfolds. Here it is.
So this is basically the postmortem concentrations or samples that were hospital blood samples that were submitted by Mr. Floyd, and we found fentanyl at 11 nanograms per milliliter and norfentanyl at 5.6 nanograms per milliliter. So this slide shows what the ratio of the parent drug to the metabolite is. So 11 nanograms per mil divided by 5.6, the norfentanyl gave Mr. Floyd a ratio of fentanyl to norfentanyl of 1.96.
How does Mr. Floyd's ratio compare to that data set?
So Mr. Floyd's ratio is roughly just a little bit below the median ratio in DUI.
So it's a lot to process with the graphs and the numbers flying around, but the basic idea is that the expert is telling the jury that they collected post-mortem blood samples from George Floyd, meaning the samples were taken after Floyd died, and they compared these samples to other overdose victims and DUI suspects after their deaths. And Floyd's level of fentanyl were well below both of those groups at the post-mortem stage. And so the conclusion was that Floyd didn't overdose on fentanyl. The fundamental problem here is that Floyd's samples, according to the medical examiner's records, were not actually conducted post-mortem or after death. They're comparing Floyd's pre-death samples with other people's post-death samples. Let's talk about something that affects all of us, taxes. The October 15th deadline is passed. If you're not prepared, you could be in for a world of hurt. Do you owe back taxes? Are your returns still unfiled? Did you miss the deadline to file for an extension? Now that we're past October 15th, the IRS is probably gearing up for some aggressive enforcement. Trust me, you don't want to be on their radar. We're talking wage garnishments, frozen bank accounts, or even property seizures. It's not pretty, folks, but before you start panicking, there's still hope. Tax Network USA has helped taxpayers save over $1 billion in tax debt and filed over 10,000 tax returns. These guys specialize in reducing tax burdens for hardworking Americans just like you. Look, I get it. Dealing with the IRS is about as fun as a root canal, but ignoring the problem won't make it go away. So here's what you got to do. Don't wait any longer. For a complimentary consultation, call today at 1-800-958-1000 or visit their website at tnusa.com/Walsh. Their experts will walk you through a few simple questions to see how much you could save. That's 1-800-958-1000. Visit tnusa.com/Walsh today. Don't let the IRS take advantage of you. Get the help you need with Tax Network USA. So to restate, there were samples of blood collected from George Floyd before he died in the hospital, according to the government's own documents. He wasn't actually pronounced dead until an hour after this incident with Derek Chauvin when he was in the hospital, which a lot of people don't know that either. And while he was in the hospital, his blood was drawn. And as the judge put it in his ruling this week, quote, the autopsy report shows that ante-mortem blood was collected. And the prosecutor's own statement from 2020 confirms that. Here's what they said at the time. This is from another internal memo. Quote, Dr. Andrew Baker said that he had the final toxicology results from Mr. George Floyd's samples. Those samples are from Mr. Floyd's hospital admission and were not acquired at autopsy. Baker said that these samples are better for determining actual blood toxicity than samples taken at autopsy. Samples taken at autopsy may have undergone post-mortem distribution. So here we have ante-mortem samples or pre-death samples of Floyd's blood. And that means that they were taken before the effects of Floyd's death could impact the samples. And here's the autopsy report, which also confirms that Floyd's samples are ante-mortem. It reads, testing performed on ante-mortem blood specimens collected 5/25/20 at 9 p.m., fentanyl 11 nanograms per millimeter. So this couldn't be any more clear. These are pre-mortem samples, according to the prosecution's own records. Now, you might be asking, what's the big deal? I mean, who cares if Floyd's blood was collected before his death or after it? Aside from the fact that he was not dead until he got to the hospital also seems pretty significant. He didn't die there on the street, as like pretty much everyone thinks happened. But even aside from that, this is a pretty significant distinction, because after death, fentanyl concentrations in the bodies of overdose victims are dramatically higher than they are before death. It's a difference of up to 900% within 8 hours of death. And that's because when you die, blood stops pumping, so blood concentrations change, and it drastically affects the way that these samples read. So what the prosecution did, in effect, was compare Floyd's fentanyl levels before this massive spike with the fentanyl levels of overdose victims after this massive spike. Of course, Floyd's levels were lower in this case because it was before the spike. And based on this apples to oranges comparison, the prosecutor convinced the jury that Floyd's death could not have anything to do with fentanyl. So in other words, when he arrived at the hospital, Floyd had a level of fentanyl in his blood that was consistent with an overdose victim when his pre-mortem blood was tested. In fact, Floyd's levels of fentanyl were more than 2 times the average lethal level that you see in fentanyl overdoses. But the prosecution hid this fact from the jury by presenting these blood samples as post-mortem. They compared Floyd's number with other people who had been dead for several hours. That's the game they played, and largely how they got a conviction. Now, it's impossible to overstate the significance of this deception. This was the crux of the prosecution's entire argument. I mean, they hit it again and again, including during closing arguments. Watch.
Let's talk about what was in the system and the toxicology report. And you heard from Dr. Eisenschmidt, right? And what he testified was that George Floyd's fentanyl to norfentanyl ratio, that the metabolite norfentanyl, that was well below the ratio of people who die from a fentanyl overdose. It was even below the median. And George Floyd's methamphetamine level, that was 94% lower than the group for driving, population for driving under the influence. Right? And Dr. Rich and Dr. Smock, they've treated patients who are under the influence of both fentanyl and methamphetamine, and they testified these drugs did not kill George Floyd. It didn't. We know that he had a tolerance because he used drugs in the past.
So again, he's showing the chart with false information, presenting the numbers as post-mortem, and then at the end of that clip, the prosecutor claims that Floyd has built up a tolerance to fentanyl, implying that because he had overdosed before, his body could handle a high concentration of the drug. But that was never proven at trial either. We know that George Floyd had used fentanyl several times before. He even overdosed just months before his death, resulting in his hospitalization. But that's very different from saying that Floyd was somehow immune to the fatal effects of a fentanyl overdose, which was never demonstrated at trial because it's impossible, it's absurd. The other major problem here is that the prosecution's witness testified that Floyd died on the street, which seems incompatible with the idea that pre-death blood samples were later collected in the hospital. Watch.
You're seeing here fatal injury to the brain from a lack of oxygen.
Minutes later, still pinned to the ground by Chauvin.
That's the moment the life goes out of his body.
So this whole trial was full of incidents like this. There was the fact that Floyd's suspected drug dealer wasn't prosecuted, which allowed him to take the fifth and avoid testifying about the drugs in Floyd's possession. There was the prosecuting attorney who was allegedly threatened with professional consequences for refusing to add charges against Chauvin. There was testimony from Andrew Baker, who admitted under cross-examination that Chauvin's knee did not cut off Floyd's airway. There was the statement from the judge in the case saying every case is about racial justice, you may remember. There was the fact that the prosecution tried to hide the tape of George Floyd saying, "I can't breathe," when he was still in the squad car, and Chauvin's knee was nowhere near his neck. In 2024, there would be a chance that a jury would see through all of this corruption and vote to acquit Derek Chauvin. But in 2021, Chauvin was never going to receive a fair trial. The threat of violence by BLM was too real. Propaganda from corporate media was still believable to millions of Americans, in part because all social media was censored. And Democrats had far too much political power. So none of that is true anymore. That's why Daniel Penny was just acquitted. And if you reverse it, and if Daniel Penny had his trial back in 2020 or 2021, the result probably would have been very different. It's also why, if Derek Chauvin is granted the new trial that he clearly deserves, I think he will be acquitted too. Hey YouTube, thanks for listening to the show. If you'd like access to my full show with no ads, you should go to dailywire.com and use promo code Walsh to get 2 months free on all annual plans. See you there.